And a Georgia County District Attorney has told the state Republican Party chairman that he could be indicted as part of her investigation into Trump and his allies' efforts to overturn the 2020 election. CNN's Sarah Murray has details.
The investigation into Donald Trump and his allies' efforts to overturn the 2020 election in Georgia appears to be escalating. We are learning that David Schaefer, who is the chairman of the Georgia Republican Party, received what is known as a target letter. This is essentially a letter saying you are now considered a target in this investigation. You could perhaps face an indictment. Now, this is interesting because it's the first target letter we are learning of in this case. So the first time that she has warned someone that we know of that they may face an indictment. It's also interesting because Schaefer had been cooperating with prosecutors. He was under the impression he was a witness in this investigation. He's someone who served as a pro-Trump elector, a fake elector. He worked with the Trump campaign to sort of organize this fake slate of electors. People around him had said he was talking publicly about it at the time, that it was only in case Donald Trump somehow won one of his court challenges. But it's very clear from this letter that he could face some legal exposure. What's not clear is if he is actually going to be indicted or if this is somehow a warning because the district attorney wants something else from him. But we can see clearly she is chugging ahead with her investigation down in Georgia. Back to you.
All right, Sarah Murray, thanks so much. All right, joining us now to talk more about all this, Michael Moore. He is a former U.S. attorney for the Middle District of Georgia and current partner at Moore Hall in Atlanta. Michael, good to see you.
It's good to see you. Glad to be with you.
Okay, so legally speaking, how big of a deal are these target letters warning of possible indictments?
Well, I mean, I'm glad to be with you today. Let me tell you, target letters themselves are sort of routine. And they're a matter, of course, as you're investigating a case and you have somebody who may, in fact, find themselves on the wrong side of the versus mark in an indictment. I really think, though, the problem here for the Fulton County DA is that she may be given the argument to the defendants or the potential defendants that this is, in fact, political. And, realize that we're in the middle of a special grand jury, a grand jury that does not have the power to indict anyway. And so, I question whether or not she's prepared another grand jury. Is there one going on we don't know about? Has there been something else that she has actually prepared an indictment to present? But there are some politics at play, too, in some of the people that she's identified. We're coming up on an election season. There will be arguments that, she may be a favorite of one candidate, and she's looking at maybe now announcing that she may charge somebody else. This puts it into a real a mess, and I think a morass. And what happens when you fish with too big a net is you often get tangled up in it, and that may be what we're seeing here. This investigation went from something that was fairly streamlined to something now that may be overcomplicating itself and causing problems down the road for her.
Interesting. But then you say this type of target letter is customary. So what are the conditions in which you'd want to execute that as opposed to just waiting until you have all the goods, to actually indict someone?
You typically send a target letter if your investigation is moving forward and you think there may be evidence that would implicate someone in the grand jury, or to actually become a defendant as opposed to a witness. Mm-hmm. But you also generally do not call people who will claim the Fifth, who have been told, you've been advised by counsel that they're going to take the Fifth Amendment anyway, which any competent lawyer would do once a target letter is issued to their client, right? I mean, you're not going to put them in there and let them go under oath left and right. You'd say, well, fine, prove your case. We'll fight it another day. But right now, we're going to take the Fifth. You don't typically bring them in front of the grand jury and make them take the Fifth question by question, in that scenario. Here, she made sort of an overbroad statement saying, well, we may be investigating Lindsey Graham. We may be looking at the GOP people. We may be looking at Trump. We may be looking at this. So there's this number of people who are out there that she may get good information from about what happened actually as it related to the vote in Brad Raffensperger. But yet we're finding people who are all now being identified as targets. They may have had good information. Now, she has the ability to offer them immunity, use immunity. She can do things like that as we go forward, but it complicates the process. It drags the process out. It means negotiation limitations on what testimony may come in. And that's the issue for her as she goes forward.
Do you see any advantages to casting the net wide so that perhaps you do end up getting more cooperative witnesses who are willing to share more information, especially as you're trying to pursue the bigger fish?
Well, I think she had information at the front end of the case where she could have looked at the bigger fish. I mean, we had a tape recording of a phone call, which by all accounts is sort of what's the basis of this claim, and that is an attempt to influence the election here. That to me would have been a case that you could have just put into a regular grand jury. You could have asked them, you sandwich it in between a carjacking case and a drug case, and you put the former president in the middle of that. You say, ask the grand jury, do you want to indict him or not based on this information? When you cast it big, when you cast a broad net, you also expose yourself to different legal arguments, to different delays, to defenses, to challenges up through the appellate court system. I'm not, again, she knows what she has, and I'm not going to armchair quarterback everything that she's doing because I hadn't seen all that evidence. But I do think sometimes there's a value to sort of the keeping it simple method, especially when you were talking about charges that involve a former president for conduct that occurred while he was president of the United States. And so that to me has to be considered as you think about which way to go and what evidence you want to put forward. Again, she's a good lawyer. They've got good people there. I just think that we're now getting to the area where you're going to hear potential targets saying, but wait a minute, why is she telling me I'm a target all over the newspaper here and every news channel in the state of Georgia, and I'm a candidate and she's supporting somebody else? And that is, I think, probably something that was a mistake to do at this point.
All right, let me shift gears a bit. Now let's talk about, the January 6th House Committee and now its subpoena of the U.S. Secret Service, these mysterious messages, where'd they go, for January 5th and 6th. Which direction do you see this House Committee being able to go with this subpoena?
I think the fact that the text messages were erased is indefensible. And my guess is whoever made that call in the Secret Service is going to find themselves stationed at an outpost somewhere, up in Alaska or someplace, because there's absolutely no reason at all. And this would be like having, the photographer, the photojournalist erasing their camera after Pearl Harbor. I mean, there's absolutely no way anybody
why would you not protect data for any
exactly
kind of migrating of a system?
That's exactly right. And so this idea that somehow we're in a bureaucracy that where we change out our cell phones or we migrate this and we change that or upgrade it, nobody in their right mind, especially at that level of government, had any expectation that this was going to be anything other than extraordinary and spectacular in its scope. And so, the fact that you bring somebody in and they may testify, that's fine, but that's a lot different than being able to look at a screen and see a direct order or direct command from somebody who may have been closer to the inner circle there. Don't do this, do this, let these people in. We know this is happening, but don't say that. These are things that you can't replicate. I mean, and that's why written evidence is so important in a trial. So I'm not at all surprised that the committee's upset by it. I would be. And I am not upset. I'm not surprised that the OIG is upset by it.
Yeah.
And so this is something that's going to have to be answered. It's a speed bump for the committee because they do have other witnesses, they do have other evidence, they have a lot of photo evidence, but this could have been important corroborating testimony that they now won't have access to and are going to have to rely on the memories of these agents. And let me tell you what the argument is about memories, and that is that memories fade over time.
Yeah.
I mean, we hear that in every trial that we go to. So somebody's going to say, well, they don't remember exactly, but this is what we think it was.
Right. Unless some of these texts are derived from elsewhere, and there is still possibility to retrieve some of those. But that's part of the big mystery, right? Michael Moore.
Right.
Thank you so much. Good to see you. Appreciate it.
Right. Glad to be with you. Thank you.